I will just respond to issues arising from his submission. So I will not take more than an hour. If it takes an hour, I will take less. I will endeavor to.
You don't have a bus?
Correct, my lord.
And that is the same position as the one of the attorney general.
That's correct.
So there is a likelihood of cross-cutting submissions.
Yeah, I will be. I will endeavor to stick by your prescriptions.
Mr. Wadaka, the same with your treatment. So if Mr. Tamago, this is appoint what, 10 minutes? To persuade me on the basis for granting the conservative vote. Correct. 10 minutes to be humility.
I need to respond.
30.
I will do my
You will?
I will do 10.
You will do 10. Mr.
Seems to be the one who stands to suffer.
Yes, actually, that is a position.
You will have the last bite on the cherry. How much timeline would you be looking at? You know, in my business, once you are client, you must respect it. So we don't call you Mr. Again, we call you Again.
Authorities that I would like to cite, Your Lordship, and in view of the insufficient. She is now homeless. She was living in that country until in that estate until the eviction. Yeah, that must be an embarrassment. Thank you much. No, my lord, from the truth, my lord.
And where is the application for contempt?
The what?
Where is the application for contempt?
My lord, I thought that to file an application for contempt may mean a judge here, Louis, Sonny Louis, used to talk in the country, used to broadcast. And the first words would be, I am Sonny Louis. All of us would be attending to listen to what he said. A man who has served the public honestly. And all the 5 presidents, I'm glad you say that. My Lord is now caught up with the high blood pressure, caught up with other things and so on, and is seen and shown as being now taka-taka. Instead of us being proud of him as a media personality who has served the country faithfully and loyally for over 50 years, a contemporary and a classmate of my late wife, Joyce Kaminwa, at Jalansi High School, is now.
Are we losing focus of the application?
My Lord, with respect, you need to know the context in which we are now operating, my Lord.
I do.
Yes, we are now in a banana republic. He is now 81 years. You have your
Because
time.
now he's reading evidence.
Yeah,
So we might want to cross-examine.
You have your time to talk. I thought you were in my group before, but it appears that you are not. Yes. My Lord, here is a young man. Now he no longer as strong as we used to know him. Yeah. He is now taka-taka, putting dust in of him. Yeah. Who is the other one? Okay. We cannot pretend that it is not. Which states as follows. He who did not see his mother when she was young thinks that his father just threw away cattle, right price. Am I right?
Yes,
Thank you. Those who did not see you when you were shining in Nairobi, they don't know what you are, how you are proud of you. He who did not see his mother when she was young thinks that his father just threw away cattle or bride price.
And how far
Can I say this to your Lordship? No, my Lord, I was going to say something to you. As and when your Lordship, my duty is to obey. As a counsel, I obey a judge. What the judge tells me, I obey. As and when you feel that you have heard enough of me, you can tell me to sit down. That's it.
The lawyer culture is not acceptable.
My Lord, the matter before you, I'm now commenting on what Justice Ojuang and others say.
Yes. And so have you got an introductory?
I'm looking for it.
Kindly look for
Which is now not usual to get one. Yeah, you are very lucky.
introductory. Your 20 minutes away.
You know, you are very lucky. You have got a very bright lawyer who within a short time can tell you. Yeah. My Lord, may I say this? What you have said about Justice Ojuang, I would add something more. And here, I'm quoting from Sir Charles Newbold,
He was the president.
President of Court of
When
Appeal.
he was the vice president.
Yes,
He was the president.
President of Court of Appeal.
Oh,
He almost threw me out of his court.
what did you not do?
Hmm?
What did you not do?
My Lord, if you would ask me what I did.
No, we usually.
No, I'll tell you what, I may I tell you what happened. I had just come from university. And one of the judges stated to me the law and told me, Hamino, and you're in breach of such and such law, a case law and so on. And he told me, Hamino, I told him that, my Lord, what you are saying is not the proper interpretation of that law at all. And Sir Charles told me that, Hamino, who are you to come here for the first time and you are now telling us that this is not the law? Who are you? My Lord, he was almost throwing me out of the window. My Lord, the point I wish to emphasize is this.
Have you gotten that decision for sin? Because you should be.
No, my Lord, I'll go beyond that decision. I'm aware of it.
Yes.
Yes.
So
My Lord, may I say this?
you are 20 minutes.
May I say to you this to you respectfully? When you have a matter of considerable public importance, national interest, and it's clear that the parties have suffered prejudice or some suffering. A court of law should intervene and create appropriate orders. In the instant case, my lord, the evictions have been done partially. One part of Woodley Street, affecting about 43 people. There are still some other people in Woodley who have not been affected at all. And the authorities can proceed to vacate them or to evict them if your lordship does not make appropriate orders.
So you're asking me to fashion and grant appropriate orders in terms of that.
Yes, so my lord. May I, I'm still going to pardon, madam. May I remind you again, Your Lordship, very respectfully, of the fact that when you are a tenant, I was stands. What has happened to my 43 tenants is that the buildings are no longer there. The structure of the buildings are no longer there. But the land is still there. If you make appropriate orders, my lord, if you give them the orders you are praying for, some of them can put up tents and continue to stay in the tents. With their families. Also, my lord, I happen to know as a fact that in the industrial area of Nairobi, you can approach some business people and say, look, can you provide me with a 2-bedroom house structure? And you will say yes. And you pay or you rent it, you put it on a vehicle, and you go and plant it on a piece of land you have. And you can continue to live in that kind of structure. In other words, some of the people I'm representing need you to give them the opportunity, but they know what they can do to occupy the plots in Woodley Estate. Again, my lord, may I ask you the way I did? Don't forget, some of them have got sentimental attachment to Woodley Estate. And they have no alternative. They have nowhere to go to. And this kind of orders you are doing, my lord, may I say they are temporary orders. Pending your hearing the case. In other words, my lord, what I'm asking you to translate the word status quo that you gave me the other day into restraining orders. And your lordship, of course, you will be hearing the case. We may call some amendments to our petition, taking into account certain realities and how they are to be tackled. In other words, my lord, my clients have suffered prejudice. They are still continuing to do so. Some of them are having to swallow tablets to lower the blood pressure. They are giving such orders in themselves would be medicine. I recall one lady, a professional planner, went through the hard course of planning here at the university. She's now in her 60s. When I say to her that the Lordship had given us the word of status quo, in the middle of the road, she shouted, "Hurrah! Hurrah!" My Lord. She was happy that you had given such words. Status quo. That's what I'm saying to you. Confirm, translate those words into restraining orders. And may I say it to you again respectfully. We honor you considerably. We respect you considerably for your experience and learning. The Kenyan people are interested in the outcome of this matter.
In the lawyer community, there reaches a point where the son must now tell the father, "Dad, you must now find a convenient place to stop."
The trouble we have, my Lord, is this. I'm not the unusual lawyer person.
But you are the one, Doctor, who propagated a contest that once born a lawyer, forever a lawyer. Virginia, Edith Wampoyo, Tim, Joash, Michiego, that was the contest. The latest Edward once born, bred, brought up Europe, was forever Europe.
I said that, my Lord. And my Lord, may I say that I've been proved right. Now that's why you hear of women permanent secretaries, women ministers. During those days, they were not there.
At what point does the son have the right to now tell Dad, Dad, it's now convenient to sit? Is it this point?
Well, my Lord, may I then, with respect, what's the time? What's the time? 2:44. Only one sentence, my Lord.
Yes.
Some of us, because of age and maladies of old age, we are supposed to eat at certain intervals. And probably take tablets at certain intervals. Can we adjourn at this stage and then we resume the hearing later?
We resume the hearing at?
Later.
How much time do you give?
It is up to you to give us some time. You talked about a cup of tea. That's why we are now concurring a cow and cups of tea.
That the first respondent proposes.
In addition, we have lodged an application seeking to strike out the is dated the 22nd November 2024. Seeks to strike out both the application and the petition dated 15th November 2024. So in light of the application by the petitioners, the one dated 15th November 2024, and the application that you have filed, the issues overlap, so I will address them contemporaneously in the interest of taking the shortest time possible. Now, as far as the law goes, once the petitioners have approached court by way of the application such as is before court, they are under a duty to adequately satisfy the parameters that are well settled in the decision of Gatirao Peter Munya versus Dixon Mwenda Githinji, which is Arokas Kraskas. So for that reason, they need to satisfy this court that they have a prima facie case Correct, my lord. With reasonable prospects of success. They also are under duty to satisfy the court that unless the sought reliefs are granted, they would suffer irreparable harm that is technically not possible to compensate in any way, including by way of monetary consideration. So that brings us now to what is the petitioner's case and who are the petitioners in the case. As per the document lodged before this court, the petitioners are two named individuals, one in the name of Joseph Godo, another one in the name of Pinto Kali, who are said to be suing on their behalf and on behalf of 41 others. So as far as the record relates, there are only 2 individuals whose identities have been declared. The rest of the 41 petitioners can be anyone on the streets. They are unknown, such that even if the first respondent was to seek for a way to intervene in their case, assuming that they are bona fide, then it will be practically impossible. Because they have not been characterized. I then now turn to the petitioners. Yes, I was at the point where I had already to the application at all. Yet, the reliefs they are seeking, the orders they are seeking, which are at, the application is not numbered, but I believe it's at paragraph 47, after paragraph 47, the orders they are seeking are an order of certiorari, an order of mandamus, which, if you consider the provisions of the civil procedure rules as provided at Order 53, Rule 7, yes.
The civil procedure rules, Order 53 apply, or is it the Mutunga rules that apply? What did the Court of Appeal say in the county government of Nyeri versus Cecilia Wangeshi? They don't apply, correct? 2016.
Well, it is in relation to the specific relief.
Let's move on to the matter. Or you want to say, Judge, I'm submitting?
Yes, just for the avoidance of doubt, there is that provision which is part.
The judge asked you a question. Do the civil procedure rules and demonstrate a basis?
Yes, and the reason why it is significant is because, my Lord, if you are asked, yes, prerogative, read. Which requires that at least what you are seeking to quash be exhibited. Otherwise, if the court is called to quash, what will you quash if there is nothing that has been laid before you, my Lord? So now to demonstrate that this petition and application, had it been properly filed by proper parties, is res judicata, I will make reference to the decision in ELC petition number 1 of 2024. Number 1 of 2024, which was between Woodley Residents Welfare Association and 4 others versus the county government of Nairobi, and there were 3 respondents and 4 interested parties. I will mention something about the parties. So there were 3 respondents and 4 interested parties.